Hello, everyone. You have to imagine that we have a virtual fireplace in front of us for our fireside chat. We're going to be talking about AI in the judiciary. I think this is a very timely conversation, and we have two wonderful speakers to join us. I wanted to begin by sharing a story from the United States. Where a member of the United States Senate, Senator Grassley, who chairs our Senate Judiciary Committee, recently held a hearing where he called attention to the fact that the judges were apparently now using OpenAI for their judicial opinions, creating hallucinations and, of course, raising a lot of concerns about the role of AI in the judiciary. Senator Grassley said that this was an area of urgent oversight. Now, I will say, having worked as counsel to the Senate Judiciary Committee and knowing Senator Grassley, I both agreed and disagreed with the purpose of his hearing. I think there is a real concern about the use of AI in the judiciary, and we're going to talk about that during this panel. But I was actually very uneasy about his use of the word oversight, because in our system of government, of divided government, and I would say in many countries around the world, the independence of the judiciary is actually a critical requirement for democratic governance. And while the legislators and parliaments may have a lot to say about many areas of AI governance, I actually think this is the one area where the legislators maybe need to take a step back and show some regard for the judiciary. So in that spirit, I'm actually thrilled to have our panel discussion today. We're launching a new report and learning more about the role of AI in the judiciary. I'm going to begin with Guilherme and ask you if you could tell us about your new report. Congratulations to you, by the way. This is a use of AI systems in courts and tribunals released in the past day by UNESCO.
Thank you very much. Thank you all for being here. It's a pleasure to be also in this conversation with Margaret, with you, Marc. I think here we have a fundamental challenge when we are people like us that are normally working with judges. When there is a new kid on the block, for example, genetically modified organisms, right? The judges eventually will be called to take a decision about that. So capacity building, training, etc., it's important. There's a new thing that was not in the law 40 years ago. But the judges themselves are not using necessarily genetically modified organisms for administering justice, right? So they are not entirely impacted by that, although their personal lives might be. Here, the story is completely different because we have a double challenge here. We need to discuss the incorporation or not of AI in the administration of justice on many different aspects, administrative aspects, collecting digital evidence, accepting or not digital evidence generated by AI, whatever, you know. But the judges will also need to take decisions about the impacts of AI in the society. And when you mix those two things, the situation becomes very, very complex in the overall conversation. So the first thing we noticed, I mentioned to you for those that were here when I spoke, we have a program called the Judges Initiative, and we have already involved in this program 36,000 judges and prosecutors from 160 countries. So everything that is here is actually based on this dialogue with judges and prosecutors from 165 countries. But when we started discussing AI with them, their first preoccupation is not about taking this judicial decisions about AI. Their first preoccupation is how we use it, right? Which is legitimate, but it's very simplified in terms of challenges for independence, for transparency, and for the actual administration of justice at the end of the day. So I won't enter into the details. You can take it. It's online available. Guilherme here that works with me has a few copies. But we tried through these conversations with the judges and with relevant actors like Margaret and so on to establish 15 principles that we heard back from these conversations and are related with this. We did a global survey with all these judges that we have been interacting in many, many years. And one thing that, and this was just after the launching of the generative AI, ChatGPT and so on, and the first thing that really caught our attention is that at that time, early days, almost 50% of the judges and prosecutors interacting with us were already using generative AI in different formats, right? But only 9% told us that they had any kind of guidance from their judiciary and capacity building efforts to actually do this, right? So there is a huge gap here. I guess now the situation is a bit better, but it's not that much better than this. So the main thing here is precisely this, how we can help this judiciary while keeping their independence. That's why this is not an enforcing document from the United Nations system of the UNESCO. It's guidance based on what we heard from them and from the different actors involved here. And then later on, maybe I can dig a little bit on some key elements of the guidance, right?
Well, thank you so much. And as long as we're talking about publications, I'd also like to put in a word for our AI policy source book, which is available in the back of the room. We've gathered the various AI governance frameworks, and relevant to this panel discussion, I happen to be a big fan of the Vatican guidelines on the use of AI, which were issued earlier this year. And there's a specific article on the use of AI in judicial activity. It's only 2 sentences. It says that AI may be used for research and administration of judicial functions, but for evidence gathering and reasoning and opinions, it may not be used. And I thought that was a rather striking division of assignments. But turning to you, Margaret, you're in a very interesting role. You work through the UN Human Rights Office as Special Rapporteur, focused on the independence of the judiciary. And I was wondering if you could say a few words about your role and some of the challenges that judges are confronting today.
Sure, thank you so much. And it's great to be here, and I think these discussions are incredibly important. So in my role, I talk with judges a lot. I talk also with lawyers and with people who are seeking justice. And relevant to this, what I'm seeing is both a push to use AI. So there's very much, there's a lot of hype about how judges should or might be using AI. A very strong push from, in particular, entities that are interested in, for example, reducing backlog of cases or increasing the productivity of judges. Alongside that, what we see is exactly what you've already mentioned, which is judges saying, well, we don't have training on this. We don't have the capacity that we need to assess whether these tools can do what they say, what the risks are, what the dangers are. And then also the fear of making those decisions being taken away from the judiciary. And so I think that is one of the most important pieces that I want to bring to this table is when we're talking about judicial use of AI, we have to remember that judicial independence is actually a human right. It's part of the guarantee of the right to fair trial, and the right to come before an independent and impartial tribunal is embedded in all of the major treaties, regional and international. So when we think about judges making these decisions, it's crucial that they have the capacity they need to do that. And that means they shouldn't have to rely on ministries of justice. They shouldn't have to rely on, for example, their IT personnel. We hear that that's often kind of who they're referred to. But they should have their own capacity and policy advisors on this so that they can make the decisions about when and how to use AI. So that would be my first message. And then the second is we're talking about people's human rights. So not only the right of independent courts and impartial courts, but also all of the rights that judges are meant to and are charged with protecting. And so when we think about the risk of error or the risk of displacement of decision-making, for example, it's not only the judges, of course, who need to be independent, but not because of their rights, because of the rights of everyone. So we have to think about that and those implications as well.
That's great. Thank you so much. I'm going to drill down now on two specific issues that I think will be of interest to both of you, but I'd also like to ask, how many people here are lawyers or lawyer adjacent? We have a fair number, right? So in the field of AI, one of the words that I've always been very uncomfortable with is explainability. We hear a lot about the need for explainability. And to a lawyer's ear, this actually sounds like a rationale to justify an outcome. And so in every one of these settings, when we're talking about AI and the law, I propose the much better term is contestability, the ability to challenge an outcome, which as a matter of logic, and read Karl Popper, is actually essential to verifying truth. If you can't verify falsity, you can't verify truth. And I noticed, Guilherme, in your report, the UNESCO report, you actually used the term contestability, and I was happy to see that. But I wanted to ask you both, is this intuition correct, that as we think about the role of AI in judicial settings, we actually need to move away from talking about explainability and interpretability, which are favored terms, I would say, in the science, and talk more about contestability, fairness, and due process?
I don't necessarily think they are excludent ideas in this conversation with the judiciary, right? Because there is one important thing here. In my discussions, and we had this conversation with Margaret earlier this year, one of the things that concerns me a lot is that I talk to Chief Justices quite regularly, or the presidents of National Councils of Justice, and for understandable reasons, they are rushing a lot to adopt whatever it is, the discussion about AI, and I'm not judging if it's good or bad, what they are doing. But one of the things that is really putting aside is that this adoption is not thinking on the huge inequalities that still exist in the access of justice, right? So if the people can't understand what's going on, and this maybe is the explainability part that is different of being able to contest this judicial decision that was taken, or a procedure and so on. This is very important. You take the case of Brazil, for example. That's my own country, although I'm an international civil servant. I'm not representing Brazil. Brazil has 88 million open judicial processes in this very moment. And there is 166 indigenous languages in Brazil. And a lot of these people are not connected. So if the Brazilian judiciary just adopts something that you necessarily need to go to a door of AI to access the judicial system, you start already leaving a lot of people behind, because these tools, they don't have this multilingualism and so on and so forth. So I think there is here a need to also going deeper in this conversation. Avoiding the hype does not mean to not use AI or whatever, or in accordance, in our view, with these guidelines, but is having a much more sophisticated conversation on the actual needs of these people that are still waiting for these 88 million processes to be taken care of, and so on.
Right, that's an important point, and I guess we would put that under the heading of access to justice.
Exactly.
Right.
Yeah, so I think explainability is still really important, and I think in particular judges need to be able to understand how AI is working. And this is something that I hear a lot from judges, that they don't understand it. And also I've had the following conversation. Well, will you think about ensuring and demanding that companies explain to you what training data they use, or explain to you how the different algorithms work and how prompts work? Well, not really, because we want to understand the answer that they give us. So that's a very disturbing answer, right? Because it says we're going to cede our power to overlook these things and simply trust what companies are telling us. That's even more dangerous, I think, in situations where you have the possibility of a system that's not yet digitalized, for example, and you don't know how the model has been trained, if it has anything to do with a particular legal system. You might have some countries, of course, where they have the funding and the capacity to create bespoke systems for their own judiciary. That's one kind of situation. But the other situation that I'm seeing is judiciaries that have very, very low resources, might not have all of their cases even digitalized, may not even have access to all the cases at a given moment, and they're being asked to assess whether and how they should use AI. On contestability, extremely important. Also, I just want to say how wonderful these guidelines are, just to say how helpful they've been to us, and also I've seen judges using them. But contestability, I think, is really crucial, not only because litigants need to come before judges able to contest the things that are being used, but also another thing I've been hearing from judges is they're not always being told by litigants how AI is being used. We're very familiar with the cases where some LLM has been used and there's hallucinated cases. But we're also talking about things like use of facial recognition to identify a suspect in a crime. The judge may never know that. They may only find out later by talking to the attorney. Oh, well, we had information about this, but it wasn't admissible for the following 6 reasons. That's a real problem. Judges need to be able to exercise the accountability over those kinds of decisions, which might be used by prosecutors in a way that could be not transparent. So those are really important issues. And I think for these reasons, it's important that judges stay in the driver's seat in the justice system. Of course, lawyers have their own rules and their own ethical guidelines, and I'm not focusing on lawyers because I do think that bar associations in many places are coming to the table with a lot of important work. But judges need to be deciding how they want to use AI and how it's going to be used in the broader justice system. It's an absolute bottom line for judicial independence.
Great. And thank you for that. I do worry about this phrase, explainability. It reminds me a little bit of the notice and consent framing from our data protection era, where we were told what the practice would be and largely left to accept it, and I think there needs to be more interrogation. I do want to turn to my favorite case and ask you both about this decision from the Court of Justice in 2022. This was the passenger name record case, and this was the gathering of data on passengers boarding airplanes to try to determine whether they posed a risk to public safety and might be a terrorist. It was challenged, the PNR directive, by civil liberties organizations. They said this was a form of mass surveillance. There was no criminal predicate. It was incompatible with the Charter of Fundamental Rights, and they raised a lot of good arguments, I thought. Now, the directive was ultimately upheld by the Court of Justice, but this is where it gets interesting. The Court of Justice looked very precisely at the type of decision-making that was being made about individuals and said that because the criteria was known and the factors were set by people and were transparent, it was permissible, right? But if a machine learning model had created criteria to optimize an outcome, it would have been impermissible. And my reading of that case is that machine learning models are not permissible in the EU to make decisions regarding fundamental rights. This is a red line. What do you think of that?
Well, I think there is a red line around decisions on individual human rights, and that is you have the right to a human judge. There has to actually be a human judge here. And I do think also reasoned decision-making is important. If the judge is not reasoning through, as in the example you give, they're not making the criteria and then assessing them, that's not reason. That's not reasoning, it's not reasoned decision-making. So I think we do see a red line there. I also just want to put on the table, there's also the right to a human lawyer. And this is something I'm very concerned about in places where there aren't enough lawyers, people don't have access to counsel, they're facing criminal charges. I'm very concerned that there'll be pressure to start using AI in those settings as well.
Well, very quickly, among the 15 principles, one is precisely that. We need to have a human judge taking the decision here. But if I may finalize with, for us, one important thing, we see this as guidance for the judiciary, but we also see this as an accountability mechanism, right? So is these people following this? And for that, one key element is the transparency of all of this, right? How exactly this is being made. And we are in a very obscure moment. But I'm glad to say very briefly that some courts, for example, the Constitutional Court of Colombia has instructed the judges to use this. The Brazilian National Council of Justice has used this in their own regulation. India Supreme Court very recently, this last week, published their white paper and are using this. And when I say this, not to praise UNESCO, because this is a collective construction with the judiciaries all over the world. So I think this is what we need. But if I want to say just one word of my preference of this, is transparency.
Great. Well, that's a great note to end on. Thank you so much for the discussion. And I guess we move to our next session.